Sabrina Damas, great colleague in Los Angeles. I used to interview her a lot for the podcast, but her firm is just on full cylinders. I don't want to bother her telling her to come on the podcast, but she does a great job reading court cases like Kevin Gregg does. Excellent lawyers both in West Coast right now. And she posts these on Twitter for years now. We'd see him. And I saw she had two articles that came out, not articles, reviews. I'm just going to read the headlines because I didn't read the court case myself. One of them said BIA, the Board of Immigration Appeals, has created a presumption that a non-detained individual who has retained private counsel can afford to pay the filing fees for an appeal. In addition, the board determined that a fee waiver with zeros in the income and expense columns is presumptively invalid without further evidence or explanation. Madam Garcia Martinez. Another one she references 10th Circuit finds BIA improperly rejected notice of appeal. The 10th Circuit had determined that the Board of Immigration Appeals improperly rejected a notice of appeal where the attorney did not sign the certificate of service because the notice of appeal was submitted through ECAS and thus automatically serving Homeland Security, Cortez v. Bondi. And then the third case, this is okay. This is another one I found on LinkedIn. Immigration reporter Rebecca Rainey, Bloomberg said the district court, DC court, tosses labor judge challenge a seasonal visa. So essentially, I had reported from another report from from Bloomberg that there was, actually, it wasn't from another lawyer, that there was a court case that said DOL can't do fines for H-2A agricultural worker visas because they have a right to go, go to district court, federal court, all this kind of stuff. But the DC court said no, for H-2B seasonal workers is different. A carnival operator had argued that had a constitutional right to contest DOL penalties in federal court in light of Supreme Court decision and SEC versus Jarkessi. But Judge Barry Howell found the work visa program falls within a public rights exception carved out by justices. Howell's ruling contradicts the recent third circuit decision involving authority of administrative law judges over H-2A agricultural workers. The facts in that case were distinct, she found. The case concerned representations made to federal agencies about the company's eligibility for visas, not violations over the terms of a worker's contract. So that was like a nuanced thing right there that I want to share with you.